The discharge effect of bankruptcy only benefits the individual filing for relief. If someone else is liable with the person filing, such other persons continue to be liable for the debt, unless he or she also files for relief. Only married persons may file a joint petition for bankruptcy relief. All of those who make application for the credit are liable for it. Even if an applicant receives little or no benefit from the extension of credit, all applicants are held liable. And even someone who is merely an authorized user of a credit line, one who did not actually sign the application, could be held liable for the debt incurred if he or she in fact took benefit from the extension of credit. In community property states, any debt incurred during the marriage is considered community debt, and the creditor may collect the debt from either spouse, regardless of who signed for it. Even if only one spouse is party to the contract, the other spouse may be held liable for the debt. In community property states, if one spouse files a bankruptcy case, the discharge in bankruptcy will not benefit the spouse who does not declare bankruptcy. In fact, filing individually in such cases leaves the non-filing spouse as the only person in the world from whom the creditor can collect. Property acquired during the marriage in a community property state is owned equally by both spouses, except property received by gift or inheritance. And in marital property states, when one spouse incurs a debt for essentials, the other spouse can also be held liable. Marriage to someone who already owns a debt, however, does not make the new spouse also liable for the debt. Nonetheless, property and income acquired during the marriage could be at some risk from collection efforts from your spouse's creditors. It is generally most practical and beneficial for married couples to file jointly for bankruptcy relief, which ensures that both spouses get a fresh financial start.